In this episode, I'm going to look at an application that is made by a partner who's got a sponsor who's based in the UK. The partner is also based in the UK. My name is Andrew Nyamayaro. I'm a solicitor at Tanlaw Solicitors. Where the partner is based in the UK, it may be a situation whereby the partner is switching from another form of visa which they have. For example, they are a student and they're now switching to a spouse or unmarried partner visa. It might be that they are extending their visa when they came on entry clearance as a partner and they want to extend their visa from the entry clearance as a partner to for another 2.5 years to make it 5 years in the UK. In such a situation, the spouse and the sponsor should either individually or together be earning at least £18,600, and they should be able to prove it by way of pay slips, bank statements, and a letter from their employers if they are both in employment. If they are self-employed or they are directors, then the evidence that is required under the financial requirement is a bit different. We should also be able to submit evidence that shows that the relationship is continuing and ongoing. Such evidence to be submitted might be bills, bank statements, pay slips, council tax notices, and information that shows that you are staying at the same address. Sometimes there might be evidence to show that you have got children together, and we might need to produce the birth certificates of the children. It is a continual requirement that the applicant should be a suitable person and should be an eligible person to be granted an extension of their visa or to switch from one form of a visa to the other under the spouse visa requirement. Let me just explain that the word partner under the immigration rules refers to a fiancé, spouse, same-sex partner, or an unmarried partner. It's an unmarried partner who is recognized under the rules is someone whom you have been staying with for at least 2 years, and there's evidence to prove that you've been staying together for the 2 years. If someone came to the UK as a spouse or a partner of a UK sponsor and they had the A1 English, they need to do the A2 at least, or maybe B1 or a better English qualification if it is a requirement that they need to meet the English requirement under the immigration rules. So this situation which I've covered is whereby both parties are legally in the country, where the sponsor is legally in the country and also the applicant is also legally in the country. However, I do have clients who come to see me where the sponsor is a British citizen or is a refugee or is on a tier 2 or a points-based application, but the partner is illegally in the UK. The question that I get asked so many times is that, can we get married? And the answer to that question is yes, you can get married. The process is that you need to notify your local registrar that you need to get married, and then once you get to go to the registrar, they'll ask you to give them certified information from the Home Office to prove that you are legally in the UK. The registrar will give you an email address which you then have to send, or your solicitor has to send to the Home Office, and the Home Office will email a copy of your identification to the registrar. Once the registrar gets this confirmation, you need to approach them and you can then book your date to get married. The Home Office can allow you to get married under the normal notices, or they might extend your notice to 70 days if they think that there is any reason to suspect that there might be something that is not proper in the relationship. They can do their searches within the 70 days to avoid people getting into sham marriages, and they can allow you to get married. Sometimes you might be even called to go to Liverpool for interviews where you're interviewed in separate rooms to try to prove that you are a couple as you claim to be. I've heard from my clients that questions such as what were you watching on Sunday, what food do you have on this day, what is your partner's favorite color, what is your partner's shoe size, have been asked to try to show that you are you are in a genuine relationship with your partner. Once you have got married to your partner, again, I remind you, my viewers, that I'm talking about a situation whereby the sponsor is legally in the country and the applicant is illegally in the country. You have got two options if you get married. The first option, which is preferred by the Home Office, is for you to leave the country and go and make an application outside the country because you're illegally in the country. But however, most of my clients are afraid to leave the country because they might think that if they leave the country, the Home Office might not allow them to come back because they were illegally in the country. But let me assure you that we've done applications whereby people have left the country and they've come back to the UK legally under the partner visa. If you decide to make an application within the UK, you don't want to leave the country, the Home Office will consider the application under the human rights of family life and private life, and if your application is successful, you'll be given a visa under the 10-year rule, which means that it will take you 10 years to get your indefinite leave to remain in the UK. If you decide to leave the country and make the application outside the country, you'll be given entry clearance for 2.5 years. You then have to extend it for another 2.5 years, and it will take you 5 years to get your indefinite leave to remain. When you make your application in the UK under the human rights application, the Home Office should want you to prove that there is a compassionate or insurmountable obstacles why you cannot go back to your home country. We call this the Chikwamba principle. You need to show that there's reasons why you can't go back to your country. Maybe you've got children, maybe your partner relies on you for their care, and you can have to produce this evidence to show that if you leave the country, then your partner might struggle looking after the children by themselves, or no one will be caring for them, or you've got serious medical conditions, or that the receiving country where you're going has got so much problems that it will not be good and proper for you to go and stay in that country. If the Home Office refuses your application these days, you will get a right of appeal because it's a human rights application which you would have made. If you need any assistance, we can assist you with such applications, whether it's an in-country or an out-of-country application where your partner is based in the UK, who is the sponsor, and you are illegally in the country. And our details appear at the bottom of the screen.